Thanks for tuning in. Today we're going to talk about landlord-tenant law, more from the tenant perspective than the landlord perspective today. Now, the very first thing that you should realize when we're talking about landlord-tenant law is that there are a variety of laws. The laws are different in every state. In fact, they're different from city to city within a state. So you'll definitely want to lawyer up in your area if you have a landlord-tenant issue. At the federal level, there are anti-discrimination laws, which essentially state that a landlord cannot discriminate against a tenant based upon their race or their sex or their religion. Essentially, you can't not rent to somebody because they're Jewish or a woman or African American. That is not allowed. Now, in some states and in some cities, sexual orientation is a protected class. Other areas, it's not. So once again, it's a good idea to lawyer up in this area. Next, there's another variety of laws at the state level. These generally deal with the contract issues of any type of a landlord-tenant contract or agreement. They will talk about the duration of agreements. They'll talk about what you can do to terminate an agreement. And one of the big topics is always the security deposit. Is it required? How much can it be? What are the maximums? State law usually governs these types of issues. After talking about state law issues, you have to think about municipality issues or city issues. What you see a lot of times there are health code violations where maybe the furnace doesn't work or different types of things. There also are issues where there is no health department in the area. Maybe you're in a rural area and there is no department to enforce a faulty furnace or something like that. At the local level, sometimes there's a slew of additional laws. These are municipal ordinances which sometimes deal with health codes or health code violations that give a tenant an additional avenue for recovery or remedy if a landlord isn't acting to repair maybe a busted furnace or something along those lines. Depending upon where you're located, you may have issues with federal law, you may have issues with state law, or it could be local municipal ordinances at play in your case. So remember, it's important to hire a lawyer that is familiar with the laws in your area. Now, when we talk about landlord-tenant law in general, these rules apply in all 50 states. The idea is that the landlord owns the property and that the tenant is acquiring the right to occupy the property for a period of time. A lease can be as simple as me as the landlord agreeing to rent to you this piece of property for, say, a month in exchange for $1,000. And in a lot of cases, that's exactly what happens. There isn't a formal written agreement. You just have an agreement that a person can occupy a particular apartment, condo, house, whatever it is, for a certain period of time. Now, the law calls these month-to-month tenancies, and that's exactly what they are. A landlord or a tenant only has that property occupied for 1 month, 30 days. The benefit of that is that if you're a landlord, you can evict somebody by just giving them 30 days notice. A tenant, they could walk after 30 days notice. They're free to go. However, most of the time, people want a little more certainty with their lease agreement. If you're a tenant, you don't want the ability to be evicted with 30 days notice. You want a little more continuity with your home. So that's where written lease agreements come into play. Landlords and tenants can benefit from maybe a 1-year lease. It could be a 2-year lease. You get into much longer leases in the commercial context, but that's really not what we're talking about today. So there is a benefit to having a written lease agreement because you can satisfy a longer term of the rental agreement as opposed to just dealing with an unwritten agreement or no agreement whatsoever, which is a month-to-month tenancy. Also, in a written lease agreement, you can address a lot of the specifics of the lease tenancy. Of course, you're going to address the term. How long is it? How many months? You're going to address the amount of rent. But you can also address responsibilities. Who's responsible to take care of the major issues or appliances within the apartment or condo? Who's responsible for the roof? Who's responsible for fixing the air conditioner? All those types of things can be addressed. Can you have a pet in the property? And is there an additional pet deposit? And that's also another big topic in these written lease agreements is the security deposit. How much can it be? In a lot of states, they'll cap the amount of the security deposit at 2 months' rent. Your landlord can't charge you any more than 2 months' rent for the security deposit. One of the most important things that a tenant can do to protect himself or herself is at the beginning of the lease tenancy to do a walkthrough. Now, a lot of people are so excited to get in, they overlook things. But I can guarantee you that at the end of the tenancy, if there's a rip in a screen or there's some damage done to a baseboard or a window's cracked, that they're going to hold you responsible for that. So at the beginning of your tenancy, you want to do a walkthrough and you want to mark each and every item where there's significant damage to the apartment or the condo or the house or whatever it is. There's also a walkthrough that happens at the end. Sometimes tenants will just want to move out and just say, waive it, I don't want to be there for the walkthrough. Yes, you do. Because if you're not there, the landlord can pick anything out in the apartment that they don't like and mark it as damaged by you and later come back and charge you for that damage by either withholding your security deposit or a portion thereof, or they could actually file a lawsuit against you for damages. So if you're offered the opportunity to be at the walkthrough, you definitely want to attend. Now, as a tenant, you have certain rights, and you have those rights in every state. One of the main rights that you have is the right to quietly enjoy the property. And what this means is that the landlord cannot harass you or bother you. Does this mean that the landlord can never come into the property? It does not. A landlord still owns the property, and they have a right to enter that property at a reasonable time and in a reasonable manner. So they can enter the property to inspect the property. They can enter the property to do repairs. They can enter the property to, say, change furnace filters, which they often will do. And you are allowed, or it is required, that they give you notice. However, that notice can be as short as a knock on the door. They're not supposed to just waltz in, and most reputable landlords will provide you at least 24 hours notice when they're going to be in your apartment or your house that you're renting. However, the courts have held that a knock at the door can be sufficient notice as long as it's at a reasonable time and if they've done so in a reasonable manner. Another right that tenants enjoy is called the implied warranty of habitability. Essentially, what that means is, regardless of what the contract says, the law in the state implies that the tenancy that you're occupying, the property that you're occupying, will be habitable, which means able to be lived in. The implied warranty of habitability means that the property is habitable. What that translates to is that you've got a roof over your head that doesn't leak. You've got a front door that locks. You've got access to utilities, sewer, electric, water. You also have access to heat. Now, it doesn't mean they necessarily have to provide that, but they have to provide you with access to it. If you don't pay your utility bill and it's your responsibility, you can't hold that against your landlord. However, the implied warranty of habitability can't be waived. A landlord can't say, well, it's not my responsibility. I realize that there's a big problem and a big hole in the roof, but I don't have to fix it because it wasn't in the lease. The law implies that the property you're renting will be habitable. Otherwise, it's a breach of the lease agreement, and as a tenant, you would be free to walk away from the lease because it would be breached by the landlord. Now, some people ask, is air conditioning, is that something that's required? In most states, air conditioning is not required as part of the warranty of habitability. It's one of those things that's considered a luxury by the courts. Another issue that often comes up is we've got a problem and our landlord won't fix it. So the question is, can we withhold rent in lieu of the landlord not making the repairs? And the answer to that question is yes, under certain circumstances, and usually there's a statute that provides several steps that a tenant has to go through to be able to withhold rent. While the short answer to that question is yes, there is a provision to withhold rent, the long answer is you probably haven't adhered to all the statutory requirements to entitle you to do so. So most of the time when people ask me, can I withhold rent in lieu of the landlord not making certain repairs, I tell them probably not, because you probably haven't given them sufficient notice. And even when you do give notice, landlords have a reasonable time to repair whatever the problem is. If your furnace goes out and you don't have heat, does the landlord have to repair that in 20 minutes? Well, no. Is 2 days reasonable? It would seem unreasonable if it's in the middle of winter and I'm cold. However, it might be the first available time that the landlord had been able to find somebody to come out there. So a reasonable amount of time is something that a judge would ultimately have to decide in any particular case. Oftentimes, clients ask me, or they complain about their landlord, and they say, well, I've got a bad landlord. He won't do this. He won't do that. What should I do? And most of the time I tell them, move. Because while there are legal recourses and actions a tenant can take, it usually takes a lot more time and a lot more money than it's worth. If there's a significant problem with your landlord in not making a repair or not doing what they're supposed to do, you can use that as a breach of the agreement and you can move out. So I usually tell my clients, why sue your landlord? Don't throw good money after bad. Use that money to find you a new place to live. That's the basics of landlord-tenant law. Feel free to make comments below if there's additional issues you would like to address. There are a variety of issues that can come up in any type of a tenancy, and it's impossible to address them all in this video. So if you have a particular issue come up, put it in the comments and we'll address it in a future Lawyer Up. Thanks for watching.
Send lawyers, guns, and money.